It's been a watershed week for Americans who pay attention to political forces undermining the U.S. Constitution and the limits it's supposed to place on the federal and state governments. The exposure came as ever so charming Senator Amy Klobuchar, Democrat of Minnesota, attempted to grill Supreme Court nominee Judge Amy Coney Barrett on various articles or opinions Barrett has offered pertaining to American jurisprudence and statutes. And the exchange didn't just reveal a lot about Klobuchar. It told us something about Chief Justice John Roberts, ObamaCare, and what the political class calls super precedents. Hi everyone, I'm Gardner Goldsmith for MRC-TV. Well, after a 5-minute political monologue dripping with enough self-righteous condescension and emotional barbs to fill a soap opera script, Klobuchar attempted to mix her mendacious fear-mongering over health care with an almost solipsistic make-believe that some kind of enumerated constitutional power actually exists to see the feds provide or regulate health care. This brought her to say,
"You have directly criticized Justice Roberts in an article in my own state in one of the Minnesota Law School journals. It was in 2017. It was the same year you became a judge. And when Roberts writes the opinion to uphold the Affordable Care Act, you said he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute." Is that correct?
And after Barrett asked for and received clarification about the document from which Klobuchar quoted, and after Barrett also correctly noted that Klobuchar was wrong to describe Barrett's criticism as focusing on Roberts as a person when her comments were about ideas, the federal appeals court judge got into the substance of her reply.
I don't attack people, just ideas. So that was just designed to make a comment about his reasoning in that case, which as I've said before, is consistent with the way the majority opinion characterized it as the less plausible reading of the statute.
It's the only way that they could get it into the Supreme Court if they pretended it was not a tax. Got to get around the Anti-Injunction Act from the 19th century. After more needless back and forth, Barrett had the opportunity to amplify, offering to Americans their own opportunity to remember the sheer, audacious, stunning manner in which Roberts and the Supreme Court majority twisted words in order to sustain Obamacare. The key action to which Barrett referred came as the 2012 challenge to the Affordable Care Act, called NFIB, National Federation of Independent Business v. Sebelius, was brought to the Supreme Court. And those who are familiar with previous analysis of that case, which we presented here at MRC-TV, will understand the importance of Barrett's point here. She told Klobuchar,
"What I said with respect to NFIB versus Sebelius is that the interpretation that the majority adopted, construing the mandate to be a tax rather than a penalty, was not the most natural reading of the statute." Which
Klobuchar appeared once more to attempt to depict as an attack on Roberts himself, despite Barrett's clear point that she was noting the error in Roberts' ruling, not talking about him as a person.
"I don't attack people, just ideas."
But the larger point is what is most important. That being that Barrett is precisely right to criticize the toweringly offensive bit of judicial dancing conducted by Roberts and the majority who ruled in the NFIB attempt to block the Obamacare mandate. And for an easy understanding of that, I'll refer you to the piece that I wrote in 2018 covering how Roberts, Ginsburg, and the leftists on the court subverted not only the Constitution, but the meaning of words and honest dealing in what became the upholding of Obamacare's mandate that American adults have to own health insurance. Now, before the Affordable Care Act was passed in 2010, Obama, Pelosi, and many Democrats appeared reluctant to define the penalty for not buying insurance as a fine, and they preferred the term tax. But when the NFIB challenged the statute, Roberts and the leftists appeared to realize that if they considered the penalty a tax, then a 19th century statute called the Tax Anti-Injunction Act would prevent the court from hearing the case, which means that we can take the opportunity now offered by Klobuchar's grandstanding to remind ourselves about what the Anti-Injunction Act does and what that inspired Roberts and the leftist justices to do in 2012. And that is something that Barrett correctly found to be improper. The Anti-Injunction Act prevents any citizen from bringing a legal challenge to a tax until after the citizen has paid the tax. Now, since Obamacare was not implemented until 2014, no one had actually paid the tax in 2012 when Roberts and his pals wanted to hear the NFIB case. So, in order to hear it, he and the leftists framed the individual mandate as a penalty.
And you actually can afford health insurance, but you just decided, you know what, I want to take my chances. And then you get hit by a bus, and you and I have to pay for the emergency room care.
That may be, but it's still a tax increase.
That's not true, George. For us to say that you've got to take a responsibility to get health insurance is absolutely not a tax increase.
This allowed the case into the court where, yeah, you guessed it, the just formed idea of it as a penalty was promptly flipped, and in the end, Roberts and the left relabeled it a tax.
If you don't have health insurance and you can't afford it, the healthcare bill helps you get health insurance. We provide you with subsidies. The only people who are impacted by the individual mandate, whatever you want to call it, whether you want to call it a penalty, a tax, a mandate, whatever it is.
Which made it easy for them to vote that it was A-OK to impose via the IRS. That's how the individual mandate, the core of Obamacare, was determined by Roberts and the leftists to be constitutional.
You can't just make up that language and decide that that's called a tax increase.
Since that time, the individual mandate has actually been found unconstitutional in 2 lower courts, and the Trump administration has removed it from enforcement by the IRS. But the Trump administration and 20 state attorneys general have brought the ACA back to the Supreme Court to challenge the entire law, saying that the individual mandate and the whole statute are inseparable, and the Supreme Court will hear the case just weeks from now. Which brings us back to Klobuchar and her evident overwrought anxiety over the possibility that Barrett might take a SCOTUS seat. Barrett clearly sees the unfounded ends justifies the means illegitimate nature of Roberts' jurisprudential dance in the NFIB challenge to Obamacare. And that ought to tell us something about Senator Klobuchar. Meanwhile, we who watch can learn that despite Judge Barrett's justified criticism of Roberts and her stand against Klobuchar's childish, we can make words mean anything we want, make-believe, deeper anti-constitutional problems persist. Those are huge and in part include an idea on which both Klobuchar and Barrett both agree in the abstract. They seem to agree that there can be what are called super precedents in constitutional jurisprudence. Those would be court rulings that, we're told, due to the idea of stare decisis, or letting the decision stand, are so old or unquestioned by the populace that they just can't be overturned. In fact, during their exchange, Klobuchar implied that these super precedents somehow take the place of what's in the Constitution, which is pretty darn ignorant and anti-constitutional and dangerous. But that's okay, she merely swears an oath to uphold it, so whatever, right? Then there's the politically popular notion that the feds can mandate what insurance companies have to cover, and the added wonder of the feds offering health care to any American civilian they like. There's absolutely no enumerated power in their so-called rule book for either of those. But we're on the brink of what appears to be a long, tax-funded, career for future Supreme Court Justice Barrett. So perhaps she'll speak about that sometime. On our dime, of course. Goodness knows, it's highly unlikely that Senator Klobuchar will ever do that. Right? Whatever. Hey, thanks so much for watching, everybody. Remember, if you're watching on YouTube, like and subscribe. Make sure you hit the little notifications bell. Sort of like the Liberty Bell. It's cracked, but it's supposed to tell you when new videos appear. We'll see you in Facebook. We'll see you on Instagram. And remember, if you want some great MRC items like this one, go to MRC-store. And please visit MRCTV.org. MRCTV.org! It's the place where you can find everything that the MRC TV team is putting together. For MRC TV, I'm Gardner Goldsmith.